All right, so the DOJ and National Association of Realtors are back at it. And so in the headlines today reads DOJ to appear in court in appeal of pocket listing lawsuit against NAR, which was a report that Inman released this morning. So I want to talk through this and kind of what's happening. But to give the people kind of just an update what's going on with this whole DOJ NAR battle, I think it's important to give context.
Right.
The overarching issue I think that DOJ has with some of the oversight that NAR has in the real estate industry, their position is to give consumers more transparency into the process. Specifically, what we're talking about today is buyer broker compensation, which is between NAR and DOJ. And now there's a new lawsuit between PLS and DOJ. But let's first give the people some context, all right? So when it comes to buyer broker compensation, the issue I think that the DOJ has is they are taking the position that buyer agent, the issue that they have with buyer agency is when an agent or a broker says to a consumer, hey, my services are free. Their position is that it's not free, that they're getting compensated 3%, and that should be disclosed to the buyer. Now, a couple things there for me, and this is what we were talking about before we turn the cameras on. The issue that I have with that is the commission is between the seller and the listing broker negotiated by the listing agent.
That's right.
So the seller is saying, here's X amount of commission. I agree to pay XYZ listing broker X commission. Do with it what you need to do to get my property sold.
Right.
To your point earlier, we don't know who the buyer is. We don't know how the buyer is going to come to fruition. We don't know if there's going to be a buyer agent. We don't know if the listing agent is going to find the buyer. We don't know if the seller is going to find the buyer.
Right. So it's almost at that point there is no victim that they're protecting, right? Mm-hmm. Because we don't know who this individual or whether they'll sell the house, period. Yeah. We don't even know if it'll get sold at that point.
Yeah. So my position on that, I guess the thing that I ask myself, when I say, okay, DOJ, what are you trying to protect?
What's their goal?
What's their goal? What's the issue? Because we're talking about commission negotiated by the listing agent between seller and buyer and listing broker.
Right.
And so, there's not an agreement. And if you're watching this and you're not a real estate agent, I'm going to give you some context around what I mean. And that is, there's not a conversation, to your point, with a listing agent and the seller around potentially, we don't know how the buyer's going to be procured. Right? We have no idea. We have no clue. It's up to the listing agent, the listing broker, to co-op with other agents, right? That's where that commission comes in. It's never a conversation up front to say, okay, here's the buyer agent commission, here's the listing agent commission. Right. It's one commission. That buyer broker then offers a piece of that commission to the other agents in the marketplace to show their listing, to bring a buyer.
Bring me your buyers and I'll split this commission with you.
That's right.
Right.
And I think, when it comes to, I think context matters. Absolutely. I think because, and I really want your opinion on this, I think because it's so common practice that there are two agents involved, that the DOJ is assuming that
they're colluding.
Tell me about that.
Well, they mentioned the word collusion in the marketplace over and over in all these articles that we've looked through before this, conversation. Mm-hmm. So it's one of those words that gets a negative connotation because it insinuates that there's something nefarious going on, right? Something bad. Someone's lurking around and plotting to exploit the consumer, right? But in my mind, collusion, it's not a negative or positive word. It's just what happens. We're colluding right now to make this video.
Yeah, that makes sense. And because I was gonna, the part that confuses me about this,
very confusing.
It's very confusing because here's the most confusing part for me, is that when the commissions are agreed upon, when the seller says to the listing agent, yes, I agree to pay you 5%, I agree to pay you 6%, I agree to pay you 7%, there's never a distinction of how that home is going to be sold. And I think the problem is this. Because it's so common practice that there are two agents in a transaction, and it's so common that the listing broker is co-opting that commission with a buyer's agent, that DOJ is taking the assumption, it seems like, that there's an agreed upon compensation between seller and buyer broker. If that was the case, I could say absolutely. You absolutely need to disclose that to a buyer agent for sure. That's not what's happening. In the real world of selling real estate, the listing the seller has no clue how the buyer is going to come to fruition. Therefore, it'd be impossible to say, okay, we're going to pay this buyer agent this, we're going to pay you this. No, it's one set commission that's paid to the buyer broker, of which they use those funds to market and sell the property by any means necessary.
They incur costs as well. So it's almost a budget. Here's 6%. You have a budget. Get my house sold for X. That's the minimum I'll take. I don't know. I don't see the problem with it like the DOJ does.
And listen, when I look at to say, okay, what could come of that? Let's just say, because if that were the case, I could see so I think what they want to have happen is that potentially buyers pay buyer agent comp, sellers pay listing agent comp.
More like attorneys where each side pays their own fees.
I can see a world like that. Outside of the United States, that's what happens a lot of times in these other countries. So I could see something like that occurring. But if that happens, and I don't know this for sure, I'm not suggesting anything, I'm just spitballing. I could see a relationship between seller and listing agent where you agree to pay me, let's just say 3%, half the traditional commission. And it's up to a buyer to compensate a buyer's agent if they want to pay that. But if that happens, Bill, I believe the consumers just go directly to the listing agent, which would be a world I would love.
Oh, right. So,
right?
Yeah.
Because the listing agent...
Now you run into dual agency problems.
That's right.
Who do they represent? Is there a conflict?
True. Yeah. That's a good point. Yeah. So what happened as of this morning is Inman posted an article about the DOJ appearing in a different case that they're not associated with necessarily.
Not directly.
So the DOJ appears in court to appeal this pocket listing lawsuit against NAR. So let's give some context there. So there are companies out there that are essentially, and I'll just kind of read this so that people...
it's the PLS versus NAR.
Yes.
People want to Google it.
Yeah. So, and I'll link to this beneath this video. So the suit alleged the defendants had violated the federal Sherman Antitrust Act and California's Cartwright Act for adopting the controversial clear cooperation policy, which requires listing brokers to submit a listing in their MLS within 1 business day of marketing property to the public. So let's unpack this. First, the federal Sherman Antitrust Act. Can you shed some light on exactly what that is?
Yeah, obviously, this thing goes back 100 years plus. So it's an old monopolistic, anti-monopoly statute. And I think, if I remember my studies correctly, it stems from like the Rockefeller era, the late 1800s, early 1900s, where these big conglomerates were emerging for the first time in American history. We talked about the Men Who Built America special on the History Channel, which portrays that era.
Yeah. So this is another hard one for me because what NAR's position is on this is when there's an agreement in place between seller and listing broker, that property must be marketed inside the MLS within 24 hours.
Right.
That's their position. Now, the PLS is
the public listing service, which is it appears like they're trying to come in and compete with the MLS, for whatever market share that they're looking for.
And what is their position? Or what are they trying? What is their goal?
You're monopolizing this information and not giving us access to it in the same speed that you get it. You're forcing all of these realtors, throughout the country to give you the information quickly, and we don't have it, and we want to use it too. And give it. And my guess would be they want to give it to the public for free, much like a Zillow type of thing.
Yeah. Well, what was interesting, so the article goes on to say, let's see. So there in the U.S. District, there's a judge. Judge John W. Holcomb in Central California.
Right.
He dismissed the PLS's case with prejudice. So let's talk about that. So what it said was, or permanently, and without leave to amend, finding that the PLS's arguments were so flawed that the case could not be saved. Right. So from an attorney's perspective, unpack that for us.
So with prejudice means like this is already determined. We can't revisit this. You don't get a second bite at the apple. That's the phrase that we use to describe it. What that means is they have to appeal to a higher court because it's done in this courtroom, right? And you can't rebring it. So typically in a lawsuit, the judge would allow a plaintiff to amend their complaint to give them a chance to make it right if it was just a technical error. So what it's saying here is it's beyond just a technical error. It's an error of law, and it's so flawed, you got to go.
So what would be interesting is to get, some more information on the case. I would love to know.
Read the opinion.
Absolutely. So, I guess giving your experience, what would have had to, it had to just be so bad that the judge was like, just get this out of here?
Right. It was a flawed complaint, meaning it wasn't sound legally. So whatever their claim was didn't coincide with the precedents, the statutes, that type of thing.
It's amazing because here's what the document said next, or the article said next. It says that the DOJ, who was scheduled to appear, which is currently investigating the clear cooperation policy, which we just talked about, has appeared to have a keen interest in the case starting at least in June. So on May 26th, the PLS filed an opening brief appealing Holcomb, the judge's decision, on June 2nd.
Right.
The DOJ Antitrust Division filed a brief in support of neither party. So I don't understand that either.
So it's an amicus brief, which if you look at the word amicus, it's Latin for friend. So what they're saying is we're not on either side of this. We're just a friend to the court, right? So here's a brief outlining our legal position and what we think the problems are, what we think the benefits are, what does public policy favor from our perspective. So here's a brief, a summary of our position filed on record with the court, but you can consider it or not, whatever.
Yeah, I mean, it's interesting. It's going to be, as more information comes out, we'll report on it. But, I guess a NAR spokesperson, they told Inman that the DOJ's request was routine in cases where the DOJ files an amicus brief, to your point, and the request does not reflect a change in the DOJ's substantive arguments or represent a new DOJ's position.
Right. So what they're responding to is they filed the amicus brief and they requested time to speak in court. That's all routine. And 5 minutes, we joked about it like, I need 5 minutes.
Yeah.
But they're coming there just to reiterate their position, quickly summarize their brief, and be gone.
Well, it'll be interesting to see what happens. I mean, because now this is obviously has to go to a higher court at this point.
Yeah. Court of Appeals. Federal Court of Appeals, yeah.
Yeah, and so we'll have to find out what happens because NAR, let's see, so they filed suit against the DOJ. NAR filed suit against DOJ, alleging the agency had agreed to close investigations into that CCP and another NAR rule regarding buyer-broker commissions as part of the settlement. So in response to NAR's petition, the DOJ revealed its brief that the clear cooperation policy restricts the choices sellers have to market their property.
Well, when this originally started, I think it was fall 2020.
Yeah.
When they announced that there was this investigation into NAR or whatever the announcement was, they simultaneously announced that there was a settlement, right? So NAR had already had it worked out. This is what we're going to do. We agree to this. I mean, in a civil investigation like that, I think it's pretty common.
Yeah.
So when they announced that was all done, right? And now, from what I read here today, it appears that the DOJ wanted to continue to investigate after the negotiated settlement and after the agreement.
What's interesting is that, so this was on Thursday, July 1st, 2021. This is right from the DOJ's website. Justice Department withdraws from settlement with NAR. So today, the Justice Department's Antitrust Division filed a notice of withdrawal of consent to a proposed settlement with NAR. So the department has also filed a voluntary dismiss its complaint without prejudice. So the department determined that the settlement would not adequately protect the department's rights to investigate other conduct by NAR that could impact competition in the real estate market, who may harm home sellers and home buyers. So it looks like the department is taking this action to permit a broader investigation into the NAR's rules. So this was back in July. So in the lawsuit, it looks like they withdrew.
Right. So the original settlement was announced in fall 2020, and then it was withdrawn in June 2021, earlier this year. So it's similar to what I was saying, that it's because they wanted to keep investigating.
Right.
NAR didn't want to agree to that, so the DOJ pulled out.
Yeah.
If you don't agree to this, we are not settling now. We're going to continue to investigate.
It's interesting. So the DOJ also released, they said, as the real estate industry's leading trade association, which is NAR, has rules and policies that affect millions of real estate brokers and agents, and in turn impact millions of American home buyers and sellers who, according to reported industry data, paid over $85 billion in residential real estate commissions last year. The department filed a complaint and proposed settlement on November 19, 2020. The complaint alleged that NAR established and enforced certain rules and policies that illegally restrained competition in residential real estate services. The proposed settlement sought to remedy those illegal practices and encourage greater competition amongst realtors. So what is your take on that?
I mean, it's the same thing that we've been talking about. MLSs control the information, and the DOJ is saying that this information should be free to everybody, and it's a consumer protection action.
Well, it is, but you said something off air that was really interesting. You said it almost seems like
they're flipping.
Well, not that the DOJ is almost taking the position to protect realtors from NAR.
Right.
Is that something you're getting from this?
Yeah, so it does seem like that on an issue-by-issue basis, that the DOJ flip-flops from protecting the consumer to at least publicly stating that they're trying to protect the realtor, which is interesting because most realtors I know, they look to NAR for guidance, protection in the industry, job security, so to speak, and I think most realtors are in favor of NAR controlling this information versus it being completely public, because then it decreases their value in the marketplace to consumers.
Well, and I don't want to go down this rabbit hole, but in another segment, we need to talk about, there's a lot of the realtors that are, I'll just say, frustrated with NAR.
Oh, yeah.
From the standpoint of...
Right. They're not doing enough.
They're not doing enough to protect us, with the whole iBuyers.
Realtor.com,
all this stuff. So that'll be another segment. So there's another report that came out. This was in September 2021. Okay, and so this was from The Real Deal. I'll link to this, all these articles below. The National Association of Realtors moves to block antitrust probe. So if we look into this article, it says that NAR is biting back at the DOJ, aiming to block the antitrust probe into the trade group months after the settlement between the parties collapsed. NAR filed a petition in federal court Monday to block a DOJ subpoena issued in July, shortly after the DOJ withdrew from its proposed settlement. So with NAR, a signal into the trade group's alleged anti-competitive practices. So the association said it was asking for the probe to be blocked on its grounds that the DOJ violated the settlement and broke the law, according to the Wall Street Journal. So unpack that a little bit.
NAR's fighting back. So
because DOJ says we're good here. I'm walking.
Yeah. DOJ pulls out.
Yeah.
And they say we're going to continue to investigate you. Right.
Yeah.
NAR is saying what you're doing is a violation of our civil rights or our privacy, whatever their argument is. But they appealed the subpoena. So a subpoena is issued from a governmental agency. In Michigan, attorneys can issue subpoenas too for information. So they receive the subpoena. We're requesting all this data. We want your computer info. We want your records. We want this, that, or whatever they're looking for. It's a subpoena. They appeal that. They're saying, hey, this subpoena is invalid. I want to go in front of a judge before I give you anything. So that's what happened in July here, shortly after the DOJ withdrew.
So the DOJ's claim that it's within its right to withdraw from a settlement, which it said has too narrow in focus to satisfy its concerns. So they're saying they have a right to
We want a bigger net. We want more information. It's almost like a discovery thing. We need to see all of this so we can determine whether there's any laws being broken.
It's interesting. So some issues the DOJ is looking into include concerns over practices that effectively create a closed marketplace for buying and selling homes, leading to higher fees and preventing competitors from offering lower costs. And that's, I think, what this whole thing, I think, is about. It's about competition, not having a monopoly over the industry, which, the position that DOJ is taking is that NAR does.
Here's something interesting.
Yeah.
The proposed settlement came during the Trump administration, but President Biden has been turning up the heat on the real estate industry, pushing the Federal Trade Commission to look into competitive issues in the industry as well. So this is how you see when policies shift, when different people get in power. It's interesting.
So what's your take on that?
The old way to look at it is that the right is sort of business friendly and the left favors more regulation over big business. That's sort of the stereotypical way people look at that.
The thing that confuses me, and I think everybody that's following the story, is what is DOJ's ultimate goal?
That's my confusion too. Like that, when I asked you, when you were telling me that we're going to do this video, I said, what's their stated purpose? Like, do they have a statement out there that explains what they're doing other than a broad, we're investigating you?
Yeah. So the last report I want to look at is, I want to go back to when the DOJ decided to pull out of the antitrust settlement to pursue further investigation. This was in July of 2021. All right. So if we look at this, and kind of what the deal was here, the Justice Department abandoned its settlement with NAR, signaling that it intended to conduct a broader investigation. So here's, I guess, it's interesting because the position DOJ took when they abandoned the settlement was like, we want to reinvestigate this. And so I guess from a legal perspective, I don't see why NAR would be confused that they're coming back to fight this.
Yeah.
They told them they were going to do this back in July.
Yeah.
Like, go ahead.
To me, so it's a separate prong of like these ongoing issues, right?
Yeah.
So before it was PLS versus NAR, you're holding all this information back. DOJ comes in, files their amicus brief, letting the courts know what they think. And this is, well, you're price fixing, anti-competitive stuff. You're not disclosing how the buyer gets paid. Representing that the buyer agent is a free service, is not in the interest of the consumer.
Yeah.
Now, personally, the words that people use may, on a case-by-case basis be inaccurate, but the overall concept is that the buyer doesn't necessarily have to pay out of pocket to their buyer agent because, they're the cooperating agent, and they get half of the commission that the listing agent agreed on.
Well, and the other issue, this will be a great segue, and just kind of our closing arguments, if you will. The other thing about that is, I think the DOJ, this is just my take on it, I could be totally wrong, is that their position is that because of real estate commissions, that the buyers are having to pay higher prices of homes.
Right.
And from my perspective, real estate commissions have nothing to do with the sale of real property.
Right.
Nowhere on an appraisal does it say, what was the real estate commission on this comp versus what was it on this comp? And does that take into consideration into property value?
Yeah, I think it's almost like there's some sort of assumption that if there was a for sale by owner situation, that they would automatically get discounted 6% or something.
And
like that.
Absolutely not. As a guy that's watch this.
Show me a seller that'll do that.
Exactly my point. And so if I'm arguing this case as the attorney, that is exactly what the DOJ is suggesting.
Right.
That the seller, if you didn't have to pay commission, are you saying, Mr. Seller, that you would now, because you don't have to pay a realtor, sell your house for less money? No way.
No, they'll put it in their pocket.
Exactly right. It has nothing to do with the prices of homes. And I think that's what the DOJ is trying to position this thing as.
Right. It's interesting because when you said nowhere on an appraisal does it show that right. So if 100 houses in the subdivision get sold for sale by owner, you have the price. And then this one that gets listed, you're using the same information to calculate that price.
Yeah, that and the point we just made. There's not a seller on this planet that says, if I don't have a realtor representing me, I will agree to sell my house for less money.
Right.
Nobody. Show it to me.
Yeah.
That, again, from my perspective, real estate commissions is they have to do with a service. in which the realtors are providing. Real estate agents are providing a service. And so it has nothing to do with how much the house sells for, how much the house appraises for,
Right.
what the buyer pays for the home. It's a separate thing completely.
Right. It's data driven, where this is service driven.
Yeah, that's exactly right. So anyway, we'll bring you guys more information as we have more information about this ongoing battle between NAR and the DOJ. We'll bring you more information. And again, this is just our opinions of this information. We're not trying to give you advice. We're just kind of giving you our thoughts. Any last closing statements?
No, that was the legal disclosure.
There you go. We'll see you guys soon. Thanks for watching.